Yeah.
Think we're alive.
I think we're live, which is why I'm turning my cell phone off. Just beeped. Thank you. So I see you, Gary. Do you see me? Because I don't see me.
Yep, I see you.
All right. Population's going in now. Okay. I guess this is why everyone waits, because it populates slowly. I always thought people showed up late, but I guess it takes a few minutes for Zoom to let everybody in.
Right. Good afternoon to the people who are on. As usual, just watching the counter. When it slows down, then we'll know that people who are trying to get in are in.
Gary, I see 1,253,000 right now. Let me see.
Sounds about right. We're going platinum.
Okay, good afternoon, everybody. I still hate Zoom webinars because I know that was a funny joke and nobody laughed. So I can't go home and tell my wife, oh, I had the room roaring with laughter ever anymore. It's the same thing. Like nobody laughed at anything. Oh, I don't
look
know
at that.
whoever did that. There's little smiley faces going by. Hi, my name is Richard Brooks, and I'm here with Gary DADDARIO. We're from Marcus Arrico, Emmer and Brooks, and we're going to do a seminar on collection of unpaid common expenses. I'm going to cover Massachusetts. I'm going to spend about 15 to 20 minutes on it. Gary's going to then cover New Hampshire for 15 or 20 minutes, and we're going to leave plenty of time for questions because that's what people seem to like the most. So stand by for questions. We'll stay as long as you want for questions. We'll be here all afternoon if you want. And we do the questions, I guess, in the chat room, or you can type them in, whichever way you want to do it. We'll pay attention to the questions as they pop up. Okay, so we will go to the first slide. And again, this is for Massachusetts. So if you want to know what's going on in New Hampshire, you have to wait a few minutes. Okay, so the first thing we're going to talk about is the super lien, because that's what everyone talks about in Massachusetts. We have the best super lien in the country. It's very powerful. And here's how a super lien works. It looks complicated, but if you look at the chart, it really isn't. So if you look at the left side, what the chart shows is the liens that exist without a super lien. So it's real estate taxes, then the first mortgage, then the condominium lien, and then any other mortgage holders. That's how it normally is. But when a condominium takes the appropriate action and gets a super lien, we go to the right side of the slide, and it shows the priority. First, real estate taxes, and there we are, the condominium super lien, right there ahead of the first mortgage. And that is why it's important, because we are ahead of the first mortgage. So what that super lien does, two different things. If the condominium ends up foreclosing for the non-payment of the fees, the condominium association wipes out the first mortgage, and there's equity. So the condominium now has some power, because on the left side of the screen, when it's behind the first mortgage, back in the 1993, before this law was passed, the association didn't have any power. The second thing that's happened since 1993, which was when MEEB started, based on us all working on this super lien together, was that the first mortgage holders, I'll say banks a lot, but it's the first mortgage holder, would start making payment, because they realized the power of the super lien, that if they didn't pay, the association would take all the actions we take and foreclose on the unit. And the banks don't like that. They want to protect their interests. So the banks will send in checks to pay off the condominium's super lien. Okay, we will now go to the next slide. What does a super lien cover? Very important to remember this, and it's the most important costs. It's the 6 months of regular condo fees or common expenses and attorney's fees. That's all it covers. 6 months of condo fees and attorney's fees. We'll talk about in a few minutes why there's more than 6 months you'll collect in the end. But right now, the simple super lien covers 6 months of condo fees and attorney's fees. It also covers collection costs. So if the management company has a collection cost, it will also cover that. But it does not include special assessments, late fees, or fines. Now, late fees and fines you can live without because it's not important to your budget. But special assessments you couldn't live without. So key here, and we're going to talk about this in a minute, is it only covers common expenses. So you cannot have a special assessment covered. So you never want to have a special assessment, which brings us to the next slide. And we'll talk about special assessments in detail in a minute.
Richard, just real quick on this one
Yep.
too. It is technically, we used to get asked a lot, you know, what 6 months are we getting as the super lien? And technically, it's from the filing of the complaint backwards 6 months, right?
Correct. On the date the complaint's filed. So you'll see that our office and other offices will file suit often on the last day of the month because we're trying to give the owner as much time to pay as possible, or the bank. But it's 6 months from the month that the suit is filed going backwards. So we can go to the next slide, which is going to cover this, Gary. Don't worry. I got it. It doesn't say it on the slide, but that's what legal action is. So to get the super lien, you have to go through the statutory process, which is pretty much what we do for you when you send the case over. So there's a couple of shoulds and a couple of musts. So here's the shoulds. The association, through its management company, or if it's self-managed by itself, should send out 2 late notices before it ever comes to our office. We don't want to chase somebody down that would have paid if they got a late notice from the association. So the association should send out kind of a friendly late notice, like you get from any other person you owe money to. You know, you're a little late on your payment. Then you send out a more serious late notice at about 45 days. Say, hey, you haven't paid yet. We're going to have to take legal action and send you to the lawyer. So the association should do that before we ever get it. But once we get it, we do the statutory notices. So basically, we send a notice to the owner, regular mail and certified mail, so they'll get it. If they do not respond, we wait a few weeks, probably a month, just about a month, and then we notify the bank, and then we send a second notice to the bank. So those are the 3 notices that go out. Often we'll send another notice to the owner to remind them to pay. And then if they do not pay from all those notices, we then take legal action, which is filing a lawsuit. And we do that before the 6 months is up, because the super lien only covers 6 months worth of fees. That's very important. Don't wait till a unit owner is 8 months behind to send it to us, because the super lien covers 6 months. We might collect it. The owner might pay it. It might get paid at some point in the future. But you'll be aggravated when the bank sends in a check for only 6 months worth of fees, and the board might be asking, if it's a board with a management company, to say, management company, why did you wait so long? Because now there's this old balance that doesn't get paid. It might sit there for years. So always get it to us early enough so we can send out the notice, all the 3 notices, and then start the suit at 6 months. After that, it's a lawsuit. We serve the lawsuit. We record it at the registry. If they don't pay, and by the way, I'll go back for a second. When the first notice goes to the owners, right now in this economy, I don't know what you find, Gary, but we find about 50% pay from the first notice. It's pretty successful nowadays, just the first notice to the owner. If not, the banks pay when they get the notices. Usually a lot of the time, by the second notice, the bank has paid you. You don't have to file suit. But if they don't pay, or if there's no bank, we file suit. And if they still don't pay, we have a hearing. And if they still don't pay, we get a judgment. And if they still don't pay, we hire an auctioneer and sell off the unit. Out of the literally thousands of cases we start, we might foreclose on 10 or 20 units a year. When the economy's worse, we foreclose on more, but it doesn't happen that often because the owner pays or the bank pays way before the auction ever happens. Okay, the next slide.
Okay, yeah, we get about, to your question, we get about a third, I would say.
On the first notice?
Take care of it off of the initial notice. And then when the lenders get their notices, it jumps up into the 80 and 90 percentile range. And by my numbers that I track, it's maybe 2% of cases that ever see foreclosure.
It's pretty rare.
Yeah. The super lien really does get the lenders to pay.
Okay, so we talked about taking prompt action, which means send out your notices and get it to the lawyer early enough, and the additional notices to the owners from the association. You want to have a turnover policy in place. You don't want to make a decision based on something other than the fact the person's behind in their fees. So a lot of associations will say at a certain date, they turn it over to the lawyer after the first 2 notices go out from the board or the management company. They would turn it over to us at a certain date rather than trying to discuss it at meetings. Oh, we feel bad for this person. It's okay to feel bad, but it's better to have a turnover policy in place. You don't have to think about it. Payment plans. Always consider a payment plan. When an owner reaches out with a payment plan, talk to the owner. If they have them email it, put it in writing, get it formalized, but don't just say no. Even if the owner offers a plan, and I see this all the time, that might last 5 years, respond to it and say, no, we can't do 5 years, but how about 6 months? It doesn't have to be 6 months. People tie into 6 months a lot, but whatever you're comfortable with. But the plan has to do one thing. It has to include the monthly fee going forward. You don't want a plan where the balance grows and grows. Because then you can get into a problem with the super lien, because you need to do the super lien at 6 months. Budget for delays in case you don't get paid, and you have some people that don't pay. Right now with this economy, you don't have to have a big line item for budgeting for people that don't pay, but think about it, because if you have a cash flow issue, you might as well have that in your budget where you have a little extra money for people that don't pay their fees. Consider amending your condominium documents to fund reserves. Some associations now are amending their condominium documents. This isn't really collections, but it ties into it. They amend the documents to say that every time there is a sale of a unit, the buyer will pay a 2-month fee to the association. A lot of our clients have done that. It might be a little questionable now because somebody has brought a lawsuit to question whether or not you can do this, but we think you can do it, and it's being done, and it's a way of bringing in money from a new owner into the association. And we usually just recommend that you do 2 months of fees. If you do this, you have to amend your documents. You just can't make a rule, excuse me, a rule about it. It has to be an amendment. Okay, next slide. Do not levy special assessments. Okay, this is the last time I want you guys to even think of the word special assessment. If you call it a special assessment, it's not covered by the super lien, which means the bank won't pay it in most cases, and now you're taking a chance on it not getting paid. Or it's just a matter of semantics. Just revise your budget and increase your condo fee, or call it a temporary monthly condo fee, or something other than the word special or assessment. Just don't use those words, and it will be collected. When you see the next slide, I'm going to show you an example. I hope it's the next slide. There it is. I call this my own world. Oh, you can't really read it. My own world record. This is a check I got a few years ago, but fairly recently. It's $169,287. It was a 1-month increased condo fee, and then they did a second one. And because we called it an increased condo fee, the bank paid it. So that's a bank check paying $169,000 that if it was called a special assessment, that bank would not have paid that, because it would have been obvious it wasn't a condo fee, and it wouldn't have been paid, and then that money wouldn't have been collected, and the association would have needed it, so they would have had to charge that to all of the other owners. I know it's my own world record that I've claimed, but Gary, do you have one more than 169? Because it's
No,
okay.
definitely not.
Somebody might, but I didn't. That was unbelievable.
I will say this on the terminology, supplemental assessment worked for a while. And then the banks and the bank attorneys started saying, supplemental is just another S word. It's really special. But the budget amendment language, that has remained successful. That still tends to work.
I think that they look for the word special or the word assessment. If they see either, they question it. If they don't, and we're dealing with bank attorneys all the time, and so we know that they live with this. And even better when it's spread out. So if you need the money quickly, try it, no matter what, spread it out, because the further it's spread out, the more it looks like a condo fee, which is why it should be a condo fee in the first place, because they don't question that. I know some associations don't want to do it because the brokers will say the unit's not marketable because it's got a really high condo fee, but it's the same thing. It's how much money is assessed, and what you pay every year. So why is it different with what you call it? It's just semantics. And some places would say by calling it assessment, it shows there's a problem with the condominium because they don't have enough money. So it's even a red flag now for banks. So just don't do it. How did my 15 minutes go by so fast? Oh my God. Drummer boy. Okay. So I mentioned earlier, you get a 6-month lien. You can get more than one 6-month lien. So our office back in about 1998 came up with this idea saying, why can't we get more than one? Why don't we call it a rolling lien? And we started calling it a rolling lien. And over time, we convinced the banks that there should be a rolling lien. Why would there just be one 6-month lien? Why can't there be more than one? So as of now, after litigation and state changes to the state law, it's clear that the association can get a 6-month lien every 6 months. So what the association can do is, in theory, if you are on top of these things, you'll never lose a condo fee. So you never call it a special assessment. You just have condo fees. And every 6 months, you put a new lien in place. So you're always going to have all of your condo fees and all of your attorney's fees and all of your collection costs ahead of the first mortgage. So it can always be paid without a problem in the end.
My
Okay.
personal record on this, Richard, is 4. Wasn't 169,000. But I have had a case where 4 rolling liens got paid when the case wrapped up.
In the same time, like they all stack together. Yeah.
Yep.
You might have, clearly there's somewhere you can get a bank to pay and then to pay again and again, 6 or 7 or 10 times if the owner doesn't pay. But yeah, 4 at once is a lot. So, but it's a very good law. Again, we have the most powerful law in the country. So take advantage of it and don't let the owners get more than 6 months behind. The next slide, which probably would also apply. This next slide will apply to New Hampshire also. So if an owner passes away, more than likely, well, I'm not gonna say more than likely anymore. Often there is no equity in the unit. Nowadays, there's equity in units because the values keep going up. But if there is no equity in the unit and the owner passes away, no one's going to pay the condo fees because the family is not going to inherit anything. So they have no reason to pay. So you treat this a little more delicately, but it's the same as a regular unpaid fee. You need to start the process. You need to get your lien in place. You don't want to just sit back and wait for the heirs to say, oh, we'll do it one day. Often you can ask the heirs to pay now. I say, look, you know you're going to inherit this and there's no mortgage on it, or even if there is a mortgage on it, why don't you start paying the fees? So you treat it like anything else, turn it over to the attorney, they'll deal with the probate and all those issues. But it's the same thing, the fees will get paid because there is a priority lien and a super lien, even if they pass away. No more slide. I think that's my last slide, Gary. But I'm gonna quickly go over a few things. So a 6D certificate. After the whole, is that mine too?
Yep.
No, that is mine. I'm sorry, not 60 yet. Okay, so this is the latest trends we see because we track this stuff pretty closely because we do so many cases. So the values are holding steady right now, so we're not seeing any issue with equity. There are some foreclosure sales by banks again. There were none around COVID time. There was 0, and then they slowly trickle back. But the banks have a lot of things that they have to do before they foreclose, so it takes them a while. But we are seeing a few foreclosures. If you get a foreclosure notice, notify your attorney immediately. They need to get the super lien filed and recorded before the auction date or your lien gets wiped out because, again, you have to have your super lien in place before the bank forecloses. So the second you see an auction notice, tell the attorney. There aren't that many bankruptcy filings, so we don't have to deal with that very often. As I said earlier, the banks pay quickly. If you have an abandoned unit, also tell your attorney because sometimes you can get the bank to go in and protect the asset. You don't want the pipes to break. You don't want frozen pipes in the winter. The association should go in there if they have to and turn on the heat and protect the unit, winterize it because you don't need to have the insurance claim or any of the problems that come with broken pipes. And it's easy enough to do, and the association has a right to go in and protect the asset. So we do it all the time. So we're coming to the spring, so I'll get less questions. But we get a lot of calls on those cold nights that the pipe broke in the unit that was being foreclosed on. So pay attention to that, especially when they're abandoned. And the other 2 things aren't that important. We'll skip that. Let me talk about 60s for a quick second. After the unit gets foreclosed, you at some point someone's going to ask for a 60. So if there's some money still owed, we do it all the time. You can use the 60 as leverage to get some money, even if the lien was wiped out, because they're going to want a clean 60 and you don't have to voluntarily wipe out your lien. So let us know if that closings happen. Winterized units. Okay. Don't get aggravated if a bank won't foreclose and that we have to do multiple liens. Some associations get very aggravated that the owner's still there, and it can be aggravating, but if you're collecting all your money, don't be aggravated because the law is so powerful. At least you're going to collect the money. I know they might be there and driving around their rented Mercedes and doing other things that you don't like, but just live with it because the fees are going to get paid. You might see the term short sale. If you see that, again, contact the attorney. There's no reason to waive any condo fees for a short sale. That'll happen when the bank is taking the unit over and not to the back. The bank and the unit owner agree to sell the unit for less than it's worth for the mortgage. So let me restate that. They sell it for less than the mortgage is valued at. So that's called a short sale. You'll see those in the future when the economy turns. You don't have to waive condo fees when that happens. People tell you do, but you don't. And if you see a deed in lieu of foreclosure, that's basically the bank taking the unit back from the unit owner. You also don't have to waive fees. The bank will usually let the association get paid in full. Okay, 20 minutes, exactly. Good luck, Gary.
All right. Thank you. So now we're gonna switch into New Hampshire collections. The process overall, I think everyone will see is very similar in terms of how it gets handled and in the general steps. I'm gonna try in this short presentation to point out the important differences. So it all starts with the budget, right? I mean, that's why boards are levying assessments, because there is some amount of money that a unit owner needs to contribute by virtue of their ownership at the association. And so I'm really starting at the beginning here, partly because in New Hampshire, they changed the law a few years ago about how the budget gets made. And by statute now, this is RSA 356B, which is the New Hampshire Condominium Act. And as I noted on the slide, this is in section 40C. The steps are that the board adopts a proposed budget. Within 30 days, the board needs to provide a summary of that budget and a meeting notice to the owners. Then there needs to be a meeting on the budget, and that meeting needs to be not less than 10 days, nor more than 60 days after they provide the budget to the community. And then at the meeting, unless 2/3 of all the owners, regardless of whether a quorum is present, reject the budget, then it is ratified and it passes. If the budget is rejected, then the last budget remains in effect. What is really important here for folks to know in New Hampshire is that although it does take 2/3 of all of the owners, which is a big number and which I have not yet seen happen, the process is important, and the board needs to be aware that if 2/3 of your community does come out to reject your budget, then the budget will be rejected. And that is different than in a lot of other states. This is a power that the New Hampshire legislature gave to the condominium communities. More reasons to avoid special assessments. Richard covered this, and I agree with everything he said there. New Hampshire provides yet another reason why you would want to avoid special assessments. And that is because by statute in New Hampshire, the special assessment process is the same process as the budget process. And so again, 2/3 of all your owners could come out and reject a special assessment. Now, while I haven't seen 2/3 of a community show up to reject a budget, I suspect that you might get 2/3 to show up and reject a special assessment if the situation were severe enough. In other words, if the board were levying a special assessment, it was thousands of dollars per unit, I could see people showing up for a meeting to say, yeah, I don't want to pay that. And that creates a real problem for boards in New Hampshire. It could, if you're raising the money because you really need it, and then the community comes out and rejects your special assessment, it's a really tough place for the board to be. And so I advise New Hampshire boards to be sort of liberal with their line items when they make the budget, and just try, as best you can to make sure that you're not going to be in a position to need a special assessment or need additional funds during the course of the year. Worst case scenario, if you come in under budget and you have extra money, for the most part, your condominium documents are going to allow you to put that into reserves. So here's a case timeline. We're not going to sort of torture the details here, but just to give everybody some idea, and this is very similar for both Mass and New Hampshire. On the left, 45 to 60 days, that's a good time for the association to start sending it off to legal. In other words, you may have given the owner a letter from the association already, maybe even a second one, and maybe at 45 days delinquency, the association's letter says, look, you owe for last month, you also owe this month. If you don't catch up by the time we hit next month, then it's off to the attorney. When we start actions, there's a 42-day response window on an initial letter that we send. That is an effort on our part to make sure that we're complying with the condominium law, with the debt collection law, with the state law, and with the federal law that also applies here. That's a safe window. It also means, as you can see, that it does take some time for things to happen. We do the title exam and the notice of default. Here's an important distinction now for New Hampshire. We need to create and record a so-called paper lien. Massachusetts enjoys an automatic statutory lien. If something is due to the association and it's not paid, then under the law, a lien just simply exists for it. In New Hampshire, you actually have to prepare that lien, put it on paper, has to be signed by an officer of the association and recorded at the registry. I put in parentheses there 6-month maximum. That is very important. Much like the super lien, the paper lien can only cover a maximum of 6 months of time, whatever assessments are due within that period. There is a case on record in New Hampshire where an association put more than 6 months on a lien. Their argument to the court was, hey, we've got to tell the truth. And the unit owner owed 9 months at the time. So our lien says that they owed 9 months. Otherwise, we're misleading. Well, what the court said was that the statute says you have 6 months to put on a lien, period, end of story. And so if you put more than 6 months, your lien is invalid because it fails to comply with the law and it actually has no value. So the timing in the lien in New Hampshire are very important because there isn't leeway there.
That's why I'm staying here in Massachusetts.
Those next notices are the ones that Richard mentioned, very similar in both states. The mortgagee gets a 30-day notice and a 60-day notice, and there's a 30-day response window there. So again, you can see that time goes by in these cases. We get asked for statuses a lot on collections, and I always try to understand the frustration for board members, and I felt it myself when I started doing this for a living. I lived at a condo. I was the president of the board at our condo. So I do know what it's like to be in those shoes, and I get the frustration. But these cases don't take time because we like to spend time on them. They just take time because the legal process creates these steps and it creates these response windows, and we have to let that time go by in order to comply with the law. Like Richard mentioned, after the mortgagee notices, the next step is going to be the complaint. If the case has to go forward, this gets filed in the court. And in both states, if you've got an investor owner with a tenant in the unit, you can attach rents. In New Hampshire, and this is a difference for New Hampshire, the statute explicitly allows you to terminate services. Any services that are provided by the association can be terminated to a delinquent unit owner. And so sometimes you can get a little creative. Sometimes you can really get people's attention. If your association has a pool and it's the summer and you start denying people access to the pool because their account is not up to date, that's an attention getter. Sometimes associations will also block people from parking if the parking is common area. So termination of services can work. We recommend that things like this be attempted after the complaint is filed, just because we don't know if these things are going to work and we don't want the case to take any longer than it needs to. So by getting the complaint in court, you know you have an action now that one way or the other is going to work its way through to resolution, even if you have to get a judgment. And so some of these alternative remedies we like to try after the complaint is filed because, you know, there's some time when the case is in the court. So the note at the bottom tells you that if you started at 60 days with a delinquency, if that's when you sent it to your attorney, and we started to do these piece of work and these notices, and we're waiting for the response windows to go by as we move forward, by the time the complaint is filed, there might be 5 months owed, and that's if everything goes very smoothly. And as has been discussed, the super lien is for a maximum of 6 months. And so again, it does become important to start cases on time. So the super lien, we've got Massachusetts in yellow and New Hampshire in blue. Richard covered Massachusetts already. What you need to know about the super lien in New Hampshire is that it's the same with respect to the 6 months of priority, but it only applies if the mortgage is dated January 1, 2011 or a more recent date. Richard mentioned that Massachusetts got the super lien back in 1993. In New Hampshire, it didn't go into effect until 2011. And so only those mortgages are subject to it. Another difference in New Hampshire, the super lien tracks off of that paper lien that you record at the Registry of Deeds, whereas in Massachusetts, it tracks off of the complaint that you file with the court. In New Hampshire, your super lien is going to track off of your paper lien. Again, it's important to mention what the super lien does not include. And here, New Hampshire, again, tracks with Mass. It does not include any amounts attributable to special assessments, late charges, fines, penalties, and interest. Rolling the lien. Richard talked about this for Mass. I mentioned that in some of my Mass cases, we have successfully had rolling liens, sometimes as many as 4 times, if a unit owner remains delinquent. That said, in New Hampshire, we unfortunately have no such opportunity. In New Hampshire, by statute, rolling of the lien is prohibited, and RSA 356B says that any association can only have one priority lien at a time. Now, if you have a delinquent owner and you have a priority lien and it gets paid, and that same owner goes delinquent again, you can establish another priority lien against them in the future, but the statute says you can only have one at a time.
So Gary, does that slow banks down from paying because of that? Because they know you can only get one in New Hampshire?
I think it depends on your behavior as an attorney. In other words, we keep the cases moving as fast as the law allows. And so the banks know that, hey, if we're going to pay anyway, we may as well stop them before they go to court and get a judgment, because everything they do adds to the legal fees, which increases the amount of priority lien we have to pay. So I think the banks that are willing to pay do still pay. But I think that part of that is that they know that we're going to continue this case, and they know that we're going to get the judgment and pursue the sheriff's sale if we need to.
Yeah, that makes sense.
This is more timeline here. So after the complaint's been filed with the court, it gets served by the sheriff. Defendants are allowed to answer. That's another 30-day period in the process where defendants can answer the complaint. Then we might file for default if they don't. If they do, we can still file a motion for summary judgment. That's where we ask the court to give us a judgment without a trial. In a motion like that, you're explaining to the court that the facts in the law are all entirely clear, so that a trial is not necessary or helpful. And when it comes to someone owing condo fees, we can typically make that argument, because the only thing the court really needs to know is that A, the defendant does own this condo, and B, that there have been fees assessed that are paid. When courts schedule hearings, there's a 14-day notice that the parties get for those hearings, at least 14 days. Sometimes it's more, depending on the court's schedule, but at a minimum, there's 14 days of notice prior to a hearing. After a hearing, we typically get judgment, and by court rules, unit owners get 30 days to pay on a judgment. So that's another period of time that we have to allow for in the process. It's great if they pay. And sometimes when there's a judgment against a unit owner, it does motivate them. If they don't pay, it just means we need to continue the process. So if the process continues, we get an execution from the court. It's not what board members think or hope for. This is just another piece of paper, this execution. That then gets provided to the sheriff that they use to levy and suspend the property. In New Hampshire, we do what's called a sheriff's sale. There isn't a statutory right to a foreclosure sale the way there is in Massachusetts. It is something we have been trying to get changed in the law of New Hampshire. The bankers lobby argues against it strenuously every time. They convince the legislature that if associations were able to foreclose on units, that banks would just give up issuing mortgages for purchases of condominiums, and the real estate market for condominiums in the state would just go down the drain. We've tried a lot to convince them otherwise because we don't believe that's true. That would be the banks putting themselves out of business. We don't see that happening. We did once have a very friendly banker by the name of Wes Blair, who was involved with CAI and was the president of Brookline Bank. He participated once in our efforts in New Hampshire, explained to the legislators as the president of a bank in a state where condos can foreclose. He told them, don't worry about it. Life goes on. You get notice. And as the bank, you can either pay to stop the association's action, or you can let them foreclose and you'll still get funds once the association gets its priority lien. But to date, we have not been successful with the New Hampshire legislature. So it's a sheriff sale where cases end in New Hampshire. The sheriff takes care of the notice and the publication of that sale. And we schedule it with the sheriff. They conduct it outside the property, and they sort of handle the administration of that sale in New Hampshire. Post-sale, buyer has 30 days to close, meaning at the sheriff's sale, they have to pay a deposit, but the sheriff will give them 30 days to pay the remainder of the money to finish closing out the transaction. After that happens, there's a final accounting. The sheriff will give us a check for the association, which we then turn around to our client with an explanation about what happened and what the money is that's coming in. Effects of a sheriff's sale. This is similar to what Richard mentioned at the beginning of the super lien discussion. We get the super lien first, with the exception of any real estate taxes that might be owed. We get super lien first, then the first mortgage is paid, then non-super lien debt owed to the condo, and then any others who might have a lien of record. Notes to remember in New Hampshire, if a property goes to a sheriff's sale, there is no super lien if the mortgage is before January 1, 2011. The mortgage is not extinguished if there's no super lien. And a unit owner, this is particular to a sheriff's sale, a unit owner has a 1-year right of redemption to pay what they owe and retain ownership of the unit. That's probably the most unfortunate part of the sheriff's sales in New Hampshire. It makes it difficult to get people to want to attend a sale and bid on a unit, because even if they're the high bidder, and even if the sheriff congratulates them as having just purchased the unit, they're really not safe until another year goes by. Because within that year, if the unit owner pays up on the account, they can retain their ownership in the unit. And that brings us to questions.
19 minutes. Okay, I was thinking that we have a bunch of questions in here already. I'll do one. We'll alternate. I'll do the first one, which is really the first two because they're similar. But Arthur Gillis, I know you're out there. You sent a question in, and I typed the answer. And when I hit type, I said it will answer it live. And when I typed that, it deleted the question, which is fantastic system. So Arthur, if you could just write your question in again. So I'm glad that the first two people were paying attention because it's very important. Don't use the words. The key is don't use the word special or assessment. So on question number one, it's what if you're doing an envelope project? What do you call it? If you can, if the project's going on for years, just call it a condo fee. Increase your condo fee. That's the simplest. Nobody questions an increased condo fee. If you're uncomfortable with having a very large condo fee during the project, a condo fee number 2 works. A supplemental condo fee works. Just the two words you don't use are special or assessment. So that answers question number 1. And number 2, it actually answers that too. Just call it a supplemental condo fee. Or again, first choice is increase the condo fee. Second is condo fee, literally condo fee -2. And third is supplemental condo fee. And when you're doing this, amend your budget to do it. So if the bank asks, hey, is this really true? It'll be minutes showing you amended your budget. Go ahead, Gary.
Yeah, and I was gonna say, lately, supplemental, I had great success with for a while, that terminology, but that was a few years ago, and then banks started saying, well, we think supplemental is just another S word for special. And so lately, budget amendment has been the terminology that seems to slide through the easiest.
Okay, that's what they want to see is a budget amendment. I haven't had the problem with the word supplemental if I use it with the word condo fee. But if you're seeing it, it's just a matter of time till the banks come down here and start asking the same question. So that takes care. So Gary, you want to do the question from W. Watson?
Sure. Am I correct? The Board of Trustees can pass the budget in Massachusetts. Is there a threshold for the members to reject a budget? New Hampshire requires 2/3. So yes, in Massachusetts, the budget is still under the purview of the board. And so they don't have that potential issue of the community coming out to say, we're not accepting this budget.
Okay, the next question is, I guess I'll do the next one. Is there any, oops, I skipped one. No, I didn't. Is there any recourse for an unpaid fine in Mass? Okay, the recourse is really against the owner because there is no super lien that covers the fine. But you give it to the attorney and they'll take care of it. Often enough, the banks will pay fines, even though it's not part of their super lien. The way we handle them when they ask for payoffs, we give them all the information so they can pay it if they want. And wittingly or unwittingly, we have banks that will pay fines. If the bank doesn't pay the fine, the recourse is the owner has a lien on their unit for the fine. If it's a $25 fine or a $100 fine, or maybe even a $500 fine, and everything else gets paid, our advice is leave it on the ledger. You could apply new fees to the old balance if the owner doesn't say otherwise, and you can pay off the fine and have condo fees due. So there's some ways you can maybe get it paid that way. But if it's a small dollar amount, it will get paid. It will be annoying to everybody maybe that's sitting on the ledger, but you can charge a late fee on it. So if you're charging a late fee of $25 a month on the fine, you're going to make some money on it. Eventually, that unit owner will sell their unit or refinance and need a 6D. At that point, it will get paid because they'll be in a rush to do it. And you can negotiate it at some point, maybe if you want. But you don't sue over a fine unless it's a huge amount of money. You just try to avoid that because the courts don't love it.
All right.
Okay, Gary.
Sure. So the next one is, I think there might have been a typo, but I think the question is, what if there is no mortgage on the property? If there's no mortgage on the property, the legal process for the collection or the enforcement of the lien, whatever terminology we want to go by, the process doesn't change. It's just that unfortunately, the mortgage holder isn't there to maybe make that payment and get you out of the case sooner. But otherwise, the steps to the process are the same. The association's rights are the same. And so if you go through the process and the unit owner doesn't pay and there's no mortgage holder to pay, eventually you get to the end and it could be a foreclosure or a sheriff's sale situation.
Okay, so then I'll read the next question. We have a resident who's thousands delinquent and has liens against them. And by the way, if this is Massachusetts, there's always a lien against them automatically. So they only pay when we push the 6-month limit, but we'll have a balance from there back. So I think the question is, with a rolling lien, can we request that the entire amount be paid? No. Yes and no. The owner owes the money. Don't forget that. The owner always owes the money. The super lien is if you can get the bank to pay it because your lien's now ahead of the bank's mortgage. So we mentioned earlier that you have to file the suit within 6 months of condo fees being due. So I'm guessing here that they started late and there's some old fees that are still due that the bank is not paying because the bank's smart enough to say, we're only going to pay 6 months worth of fees. So you cannot collect the money via the rolling lien. It's only going to be 6 months and then another 6 months, always starting with when the lien is filed with the court, the lawsuit. That doesn't mean the money's lost. It just means the bank isn't going to pay it. So if the owner goes to sell it, they're going to have to pay it. If the owner decides to transfer it to a relative, it's still due. The new person that owns it has a lien on their unit. You'll get it one day, but if it's fines and late fees, okay, well, those aren't a loss to you. They have to sit there. If it's unpaid condo fees, it's unfortunate. And you could go and foreclose on that lien if you wanted. So let's just give that example. Let's say you started 12 months late and there were 12 months that weren't covered by the super lien. And so there's thousands of dollars due in old condo fees. The bank keeps paying the current fees because you're doing super lien actions. You could foreclose on that old lien, but none of those legal fees are covered by the priority lien either. So we tell clients it's probably safer to sit back and not do anything and collect it eventually. But some clients insist, and we can foreclose on the unit. It's subject to the mortgage. So then the question becomes, is there equity in the unit? If the person bought the unit long ago enough and there's plenty of equity, then you can foreclose on those old condo fees and sell the unit subject to the mortgage because there's equity and you can do it. We don't do that often, but that is an option if you get to that point.
Okay, next question, in Mass, do late charges and interest become part of the super lien? That one unfortunately is a hard no. That is both for Massachusetts and for New Hampshire as well. The statutes in each state define what the super lien is and is not, and they explicitly say that late charges, interest, special assessments, and other extraneous items are not part of the super lien.
Okay, there's a lot of questions pouring in still. Okay, the next question. Great seeing you, Richard. You still look very good and young, and oh, that doesn't say all that, but just say great seeing you, Richard. Hi, Arthur. Good to see you. Haven't retired yet. No, not yet. Late notices. A late notice is via email acceptable for the first friendly notice. The answer is yes, because you're not doing a statutory notice. The lawyers do the statutory notices, which have to be in writing, certified, and first-class mail. But the association certainly can send out a late notice via email. Just make sure they get it, because you'll hear all the time that they never got the late notice and didn't know they were behind. Once management sends unit owners to the attorney, should the trustees stop trying to negotiate with the unit owner? Yes, it's better. I mean, at least if you're going to do it, talk to the lawyer about it, say they want to talk to the owner so that we know what's happening and we can kind of control it. Because the last thing you want to do is have different messages being sent by the board and the attorney. But most of the time, it's better for the board. They don't have to talk to the owner. You know, they can put blinders on and let the attorney do it in the management company. So it's probably the best practice is let the attorney handle it. And we will negotiate with the owner. We want them to send in a payment plan, so that it's perfectly fine. Next
All right.
one.
The next one says, hello and thank you for the seminar. Can other legal fees not associated with a collection action be included in a Mass lien? Here again, the answer is going to be the same for both Mass and New Hampshire. Legal fees for services other than the collection are not part of the super lien, because the super lien is specific that it's the legal fees associated with the collection action. But other legal fees can be included in a unit owner's balance. They can be included in the non-super lien part of the lien. In New Hampshire, they can be part of the paper lien that you record. In Massachusetts, they can be included in the lawsuit that you file when you're asking the court for a judgment for all of the money that's owed to you. So in a general sense, other legal fees are part of a lien. They just don't make it to the super lien because that is specific to collection related legal fees.
Okay. Next question. In Mass, our board, okay, I like this one. Our board, and like when people are focused on the special assessment, our board needs $255,000 to repair a unit. There's 48 units. The property manager advised us to use supplemental assessment. Now they're worried, Gary. They're worried because the word supplemental and assessment are there. This action is pretty much in motion. Is there any recourse at this time to change the language? You could go back and have a board meeting and say, and recast it and then change it on the ledgers. Because I think that's okay. I've done that before. But the board's the one that determined what it was, even though the management company said that. It's just the word assessment. If it was a supplemental fee, it would be okay. So admit to me, Gary doesn't like the word supplemental up there in New Hampshire either, but we haven't seen that problem yet down here. But if you want to, try and have another meeting of the board, say we're changing the way what we're calling this, and put it in the minutes, that it's now called I guess a condo fee two, or whatever you're gonna call it, condominium fee increase, whichever you want to do with those two, or supplemental fee, I think you could do also, and I know Gary doesn't. And then have that in your minutes and then change, but the key is to change it then on the ledger, because that's where the banks see it. They see it on the ledger, they see the word special assessment, because they ask for a payoff, we mail it out, we email it out, and they see it and they say, oh, we're not going to pay this. So they don't really go back to the minutes all the time. So if you can change it on your ledger, you'll be good.
All right. Next question is, what document needs to be amended for the 2-month fee to the reserve? So this would be to the transfer fee that was mentioned. And in Massachusetts, you're going to be amending your declaration of trust. In New Hampshire, you're going to be amending your bylaws. In both cases, those documents, the declaration of trust and the bylaws, will most certainly include some language already that talks about the sales and transfers of units, and the fact that, you know, in New Hampshire, what gets referred to, in Mass, what gets referred to as the 6D certificate needs to be requested. In New Hampshire, it's often referred to as the resale certificate, but those would be the documents. And if you take a look at your documents, there's probably some language already about the sales of units, and then that would be the place to add some language about the transfer fee. That does need to be done very carefully, because at our firm, we recently discussed a case that was decided recently, and if the transfer fee is not done properly, courts will not be a fan of it and might decline to enforce it. So definitely something to do through your legal counsel to make sure that that gets done appropriately.
And just to emphasize that the board can't adopt that. It's going to be a unit owner vote. It's not, you just can't make a rule. I've seen some boards do it via rule, but that's not going to be enforced if anybody questions it at all. Okay, I guess I'm going to get the next question, which is going to be the hardest of all. Will this recording be available for replay? Julie, who's listening, probably is going to say yes. I'm going to say yes. Just email us and we can get you that. So my email, because Julie's down the hall that can do this, is rbrooks, like Richard Brooks, rbrooks@meeb.com, and we will tell you how to do it. So that's my easy question. You're next, Gary.
All right. Next question is, do the first 2 statutory notices need to be registered mail and signed for in order to be valid in law? Often we will find that folks are quick to say they never received the email, the notice, etc. So I could tell you that we send them out, those first 2 notices, we send them both by first class, regular USPS mail, and by certified mail as well. Sometimes we don't get the certified cards back. Sometimes we get the certified mail card back and it says it was refused, or that it was attempted 1, 2, 3 times. They usually list the 3 dates, but that the person never did claim the certified mail. However, because we send it out both ways, there is going to be a presumption, if you end up in court, that the notice was received if it was sent by first class mail and you didn't get the first class mail bounced back to you. So we find that even if the certified mail card, if that situation gets a little bit strange, as long as the first class mail didn't bounce back, the combination of those 2 things, in my experience, have always been acceptable to a judge.
I agree. I'm not quite sure I understand the next question, but can insurance companies cancel HOA coverage if there are liens involved? I'm going to assume that's the master policy we're talking about, not the individual homeowner's policy. And I've never seen that. I don't know why they would. It's not really anything to do with the insurance company. Maybe a D&O policy, they might care a little bit more if they saw that owners aren't paying. But the liens are there automatically in Massachusetts, and the insurance company would want you to collect the HOA fees, because otherwise you won't be able to pay the insurance company's bill, which is exorbitant nowadays. So I don't see any issue with that at all.
I might be reading into this, Richard, but maybe this question stems out of the fact that FHA has some standards. If the question is really about a property being affected as an FHA property by liens, then yes, they do have within their guidelines percentages, and you have to be within their percentages of how many units at the association are delinquent. And otherwise, if you have too many delinquencies, it can affect your FHA, but that's not your insurance. That's just whether or not people buying at the association are going to be able to get an FHA mortgage. But maybe the question
Yep.
relates.
Yeah, actually, Richard, who wrote that question, if you want to type it again, if it's more specific, if we didn't answer it, just write another question at the bottom. We'll see it again. So, Gary, you want to take the Leo one? Is that your turn, I think?
Yep, sure. What about an investor-owned unit in Mass, which is rented and HOA fees are not being paid? Can rent be applied toward the unpaid amount? The answer is yes. You can attach the rent in both Massachusetts and New Hampshire. That is provided for within the respective condominium statutes of the state. It does require that specific notices be sent. They have to contain specific information. The mortgage holder also needs to be notified. But as long as you do the process right, if those circumstances exist, then you can get the rent, provided, of course, that the tenant complies. Every once in a while, in these circumstances, we hear from a tenant who says, I'm sorry, I got your letter, I understand your letter, but I'm more afraid of not paying my rent to my landlord than I am of not paying it to you. And so sometimes the tenant doesn't comply, but the remedy is there. You can try it. If it works, that's great. If it doesn't work, then I always just continue with the process. Particularly in Massachusetts, if you go to court and get a judgment, you're going to be allowed to conduct a foreclosure sale of that unit. And once people start getting foreclosure notices, whether it's the owner, the mortgage holder, somebody's going to sit up and take notice and make sure the association gets paid, because when you're about to foreclose, in my experience, it's only about 2% of the time that you actually have to show up on that day and really have the sale.
Okay, my next question has a little complications, so I'll try and just summarize it. The chairman of our 3-unit association sent an email in 2021 to notify to have personal items be removed from the basement common spaces and to notify the chair once done to avoid fees, which are probably fines. This was generated by the chairman only. Okay, that's the first problem, maybe. The chairman might not have had power by themselves to do that, so the notice might not be any good. And typically in a 3-unit association, a lot of actions have to be done by all 3 owners unanimously. It all depends what the documents say on this one. The real question at the end says, are fees currently being accrued? Well, that would all depend on the association if they decided to fine daily while the violation was going on, and how can they be collected? Then if there are fines being accrued, they'd be collected by the lien process. It would not be a super lien. And again, it probably needs all 3 owners to vote on doing that, which is why 3 units condominiums may have a tough time collecting. It could just say the majority of the board, in which case it would be the majority of the board. But you need to look at those specific documents to answer that question.
All right. The next one includes a hi, Richard. But
Hi, Courtney.
I'll see if I can answer it. And Richard, obviously you can add to it. If the board is mandating a service to have HVAC cleaning and inspection, and owners are responsible for the service, what happens if we have a current lien on the unit for a condo fee? Will the payment for service stand, or should we defer maintenance? I don't want to, but should we let it sit on the ledger? So a fee of this nature, something that is sort of, outside of the budget, as we've been suggesting today, may or may not be able to get collected as part of a super lien, depending on how it's going to show up on the ledger. If it's going to show up on the ledger as something that's not going to be a super lien item, then chances are it's an amount of money that you might want to let sit on the ledger. just because it might not warrant all of the legal fees and the process. You know, it's for some finite and fairly small item. But if the board is adamant about it, and if the board doesn't want to let it sit, they do have the right to pursue anything that's owed to them. So they can undertake the process if they wish to do so, even if it's not going to be a super lien item.
Okay, is there a difference in process if the unit is a 40B in Massachusetts? No, same process, exactly the same. There's nothing different. It's just the 40B unit is a 40B unit, and so they may have a lower condo fee, but it's the exact same process. That was an easy one.
Maybe an impact, Richard, at the very end, if it gets that far. Sometimes the regulatory agreements on the 40Bs don't allow us to foreclose in the same way if it really comes to that. The good news there is that the regulatory agency that handles the affordable units in that municipality will sometimes work it out. I've had cases where they actually pay so that the foreclosure isn't going to be an issue, or you might have to involve them in the foreclosure so that they can vet the bidders. In other words, if the unit is going to remain an affordable unit, then the only people who can buy it are people who qualify for affordable housing. And so sometimes they get involved in that piece. So I would say, I agree with Richard, the process is the same, but know that if you get to the very last step of the foreclosure and the foreclosure really needs to happen, there might be a little tweaking at that step.
That's actually, Gary, that is a much better answer, because that maybe that's what they meant by the question. I'm sorry. The 40B at the end does change it. And yes, we see the same thing down here in our office, because we're in the same office but different locations, Gary and I. But the lenders step in. They do not the lenders, the town, municipality, the regulatory agency. They want to make sure these units stay 40B units forever, because that's the whole purpose of it. There were some times back in the day where these things expired, so it wouldn't happen. The 40B wouldn't be there anymore. But for all the new ones, it doesn't happen that way. Okay, so now I'm confused. That was my question then. So this is yours then, Gary. Back to you.
Okay, do you need to indicate how long the condo fee 2 is in effect, the time for repayment? So that question might pertain to the board's vote. In other words, the question might be about whether or not the board can make a second condo fee due this month, next month, in 6 months, over the course of 6 months. In which case the answer is yes. It's really up to the board in Massachusetts anyway. It's fully up to the board, you know, what assessments they put in place, when they're due, and what, if any, time period owners have to pay. In New Hampshire, it's different, because if you're going outside of the budget into what would be a special assessment, you just have to bear in mind that the community might reject it. And so in New Hampshire, that might provide a board who's desperate even more motivation to say, okay, we have to do this, but we're going to let you pay it over 6 months. Because in New Hampshire, the board runs the risk of the community rejecting it. This question might also be asking from a ledger perspective, you know, what appears on the ledger or needs to appear on the ledger. If that's the question, I would say that then condo fee number 2 is only going to appear on the ledger once it's actually due. And for each month thereafter for as long as it lasts. And then whenever it stops, it just kind of drops off the ledger again.
Yes, I've never seen a date on the ledger saying it when it ended. And you probably don't want to do that, because then you're supposed to adopt the budget every year, not for the next 20 years. So you wouldn't, it would just be an odd thing to put on there. Will assessments be paid as part of the 60 process when a unit is sold? Okay, 99.9% of the time, yes, because of 2 things. One is the buyer doesn't want to pay the special assessment. They want the seller to pay it, because it was against the seller. when they own the unit. Secondly, if there's a bank involved with the purchase, the bank is not going to allow the special assessment to be outstanding, because then it's ahead of the special assessment will be ahead of the first mortgage holder, and they're never going to allow that. So it's almost always done that way. It's possible that the buyer and the seller could agree that the special assessment will be carried forward, especially if it's a monthly one, that you call it a special assessment for the next 12 months. The parties just agree. But the association's role in that is to put it on the 6D and not worry about it. Because if it's a monthly fee, it's okay if the new buyer pays it for the next 6 months as long as it goes on. That's an okay thing to happen. But normally the bank's not going to allow it to happen. So people get worried it's not going to get paid. It will get paid one way or another as long as it shows up on the 6D certificate. That's it for that one.
Okay, next question relates to the 2-month fee again. This would be for those associations who impose a transfer fee. This one says, is that 2-month fee with purchase considered capital contribution, which would be returned? The answer is it would depend on the language of the governing documents. And, you know, just maybe a week or two ago, I would have answered no, it never gets returned, because I had never seen that language before. But within the past week or two, for the first time, I had an association have me looking at their documents, and the documents had a transfer fee, but there was also a process whereby when someone was leaving, they could apply to get that money back because they were leaving the association. I've only seen that once in the past 22 years. And again, unless that language were there, unless there was a language that said that that money comes back, once it's paid into the association, it stays in with the association.
And there'd be no purpose in amending your documents to collect the 2-month fee if you had to give it back. The purpose of the 2-month fee when we're doing these amendments is to get extra money into the association that they can keep. If you go way back, Gary, when I was a kid, the purchase and sale agreements actually said that the buyer shall pay to the seller their share of capital contribution. So it was a reimbursement. I think the brokers hated it because it was a pain in the butt. They had to calculate it all the time. So it's no longer in any purchase and sale agreements. And that actually answers, we'll count that, Ellie, as both your questions, because it will be an escrow, I guess, if they gave it back, but you don't want to do that. So the next question is, what's the difference between a non-priority condo lien and a super lien? Okay. The non-priority condo lien is for everything other than the super lien. So the association basically has a lien automatically in Massachusetts, just like a real estate tax lien. It's automatic. That's why people ask for a 60 to prove that there isn't a lien. There's an automatic lien for everything. The super lien is when we take the steps to send out the notices and put a lawsuit in place. Then there's a super lien, and that lien jumps ahead. It's the first slide we had. It jumps ahead of the first mortgage. So there's still a lien for everything else behind the first mortgage, but ahead of the first mortgage is a super lien, which is for 6 months of condo fees, no special assessments. I know we say this a lot. 6 months worth of super liens, attorney's fees, and costs.
All right, next question. Best question to get ever. Are you accepting new clients from New Hampshire? The answer is yes. Always happy to work with new folks. And you can just contact us here at the Merrimack office. I think the info is on the screen, might be blocked by the chat in my case. Yeah, my email is there, the phone number is there for the New Hampshire office. And yeah, we're always happy to work with new folks.
I think it's really it, because the last question was trying to clarify the prior question about the priority lien and the difference between that and a super lien. So the takeaway from this is never call anything a special assessment, and always, in my 2 takeaways, and always, after you send your reminder notices, get it to your lawyer on time so you don't have any opportunity to lose any of these fees. You have such a good law in Massachusetts that you shouldn't ever lose a condo fee, because we can roll the lien and it works very well. And we have very happy clients that collect all of the money all the time. So do that. Any takeaways? What's your takeaway, Gary?
Yeah, I would say the same. In fact, the next question is about the same subject. He says rephrased. What's the difference between a non-priority condo lien and a super lien other than the priority in being paid? That is the difference. I mean, the major one, the practical one that you're gonna feel is the priority within which they're paid. The other difference is that your non-priority lien can include things like late fees and penalties that the priority lien just never gets to include because the statute says so.
Now, there's a new question that just came in, Gary. It's New Hampshire, so I'll let you answer it.
Okay.
Anybody that wants to leave, I know you're all sitting in the room looking at us. The old days you couldn't leave, but nowadays you can just hang up. So, but we have 59 people still listening, so this is good.
Okay. In New Hampshire, does a board have the legal right to impose a lien to recover their attorney fees from the unit owner incurred when they demand an eviction of a tenant who falls into a protected class, but the tenant hires their own attorney to oppose the eviction and requests a reasonable accommodation? Since a reasonable accommodation process is between a tenant and a landlord, what involvement should a board have when a reasonable accommodation agreement request has been made? Does a board have the legal right to have any input into the reasonable accommodation? And if the board hires an attorney, can they ask the unit owner to pay their fees? Should a condo board be involved in the process? And if using an attorney, are those fees recoverable based on the below provision in the condo bylaws if the unit owner has filed the eviction notice as requested by the board? Is there anything specific in federal or New Hampshire law? So there is a whole lot in that question. Most of it does not deal with today's subject matter of collection, but I'll do the best I can. I'll start with the basics. The association's relationship is with the unit owner. That's who is a member of your private organization. A tenant is not a member of your organization. So generally speaking, we advise boards to deal with owners and not tenants. If a tenant were to make a reasonable accommodation request, that would largely be between the owner as their landlord and the occupant as the tenant. If the reasonable accommodation were going to affect the common areas, maybe the accommodation is for a ramp outside, for a wheelchair or an additional railing or something of that nature. If it's going to affect the common areas, then the unit owner doesn't have the ability to do that on their own, because unit owners aren't able to impact the exterior. At that point, it should be the unit owner and not the tenant who comes to the association. And then at that point, I think I'm going to summarize my advice by saying that the board should really get their attorney involved. When it comes to reasonable accommodations, there is an analysis to be made, but there are questions that can be asked, questions that cannot be asked, documentation that can be requested, documentation that can't be requested. And if the situation is mishandled, then the association will typically be on the wrong end of a claim for discrimination against a disabled person. And so if you do, as a board, find yourself facing a reasonable accommodation request, I think that's something you want to deal with your attorney on.
Not that I know anything about New Hampshire law, but in Massachusetts, the attorney's fees involved with the misconduct of a unit owner or their tenant are a lien on the unit, and you can charge it back to the unit owner. But there's got to be misconduct involved. And looking at this question, it seems like maybe they really want to know about the answer or the answer to the attorney fee question. I don't see how you could ever charge the attorney's fees that the association incurs back to the unit owner based on this fact pattern. And definitely not in Massachusetts, so I doubt in New Hampshire.
Yeah, New Hampshire is actually even a little bit more dicey when it comes to the general chargebacks. Unlike Massachusetts, the New Hampshire statute doesn't say if the unit owner engages in misconduct, then the association can assess their legal fees. In New Hampshire, the statute says that in a dispute between the association and the unit owner, the prevailing party will get their legal fees in court. And so New Hampshire plays a sort of high stakes game in that if you're the association and you go to court with a unit owner and somehow you do not prevail in your case and the unit owner does, then the unit owner can actually get their attorney fees from the association. So in New Hampshire, it's a dicey and high stakes game. I would agree with Richard that a reasonable accommodation is not going to be considered misconduct either way. And the laws that pertain to reasonable accommodations and such, for the most part, don't really allow fees to be charged, at least not to the disabled person. And so it comes up a lot with pets. If a disabled person is allowed to have a pet in a no pet building or an emotional support animal in a no pet building, you can't charge them fees for that. You can't charge them for an agreement. You can't require that they have insurance on that pet because the law prevents disabled people from footing expenses, any extra expenses, because of the fact that they're disabled. So chances are those attorney fees are not going to make their way back to the unit owner, and it's going to be what you might call a cost of business for the association to deal with that particular issue.
Well, thank you all for attending. We try to do a seminar, a webinar every month, although the summer is a little tougher. So keep an eye out for our newsletters and our notices about these. We try to cover all the different subjects that come up. We do a lot on collections because people always ask that. But we had a seminar last month with 503 people signed up. So a lot of people like these webinars. So we're going to continue doing them. Keep an eye out and please attend.
Thanks, everybody.
Bye-bye.